Good morning and welcome to Wednesday morning's online seminar. Today we are lucky enough to be joined by Mr. Jon Sharp, consultant solicitor, all the way from sunny Scotland. At least I'm assuming it's sunny, Jon.
It is actually, yes.
Excellent. Excellent. He's going to be talking to us about project security. And as always, if you have any questions, he's happy to answer these, but please pop these into the chat or Q&A tools in the bottom bar of your Zoom screen. If there's something specific you'd like to speak to Jon about, please feel free to email him. It's Jon Sharp, Jon Sharp, @silverllp.com if there's something you don't particularly want to raise in an open forum. Okay, Jon, I will hand over to you and disappear into the background.
Thank you very much, Julie. Good morning, ladies and gentlemen. Trust that you're all well. So, project security. I shall move on without any further ado. That's me. Less said about him, the better. All the details are on the website, etc. Have a quick look at the agenda, what we're going to be discussing this morning. The need for security in construction contracts, design liabilities. We're going to look at some standard form contracts, key provisions and mechanisms. We're going to look at common problems and then third-party rights, collateral warranties and bonds. Okay, so bear with me and we shall begin. The need for security in construction projects. I think probably everyone realizes this, but I'll just repeat it. There is a very strong principle of English law called privity of contract. And it's fundamental to how the English courts look at contractual obligations. And it was explained by the House of Lords in Dunlop Pneumatic Tyre Company Limited against Selfridge and Company. And the law of England, certain principles are fundamental. One such principle is that only a person who is party to a contract can sue on it. Now, there are one or two exceptions to that, but not many. And I think probably everyone realizes that you have to be a party to a contract to enjoy the benefits under the contract and indeed the burdens of the contract. So it protects the parties to a contract from claims from strangers, but there are commonly times when the parties to a contract expressly agree that somebody else can have some of the benefits from a contract. For example, under JCT-D&B 2016, it is stated that other than such rights of any purchasers, tenants and or funder as take effect pursuant to clauses 7A and 7B, nothing in this contract confers or is intended to confer any right to enforce any of its terms on any party who is not a party to it. Okay, so you have to be a party to a contract to get the benefits of that contract and be subject to the burdens of the contract. Now, these next three slides show the contractual relationships within a normal construction contract. I think it's important to remember as well that, for example, the contract between the, say, subcontractor 1 and the contractor, and subcontractor 2 and the contractor, and subcontractor 3 and the contractor will all be slightly different. It would be good in construction contracts if all the contracts followed more or less the same format, but they don't. They're all different. So not only are all these parties parties to contracts between, say, employer and designer 1, employer and designer 2, but each of those contracts will also be slightly different. So it becomes complicated quite quickly. And there sometimes will be contractual benefits that have conferred to other parties as well. So not only have you got the main contracts, you may have them. Also, design 1 will have a contract with the fund, etc. So these three slides show really the contractual relationships between the parties and just how complex they can get actually really rather quickly. There are proposals, and I think the JCT Constructing Excellence contract is probably the best example, where they are trying to make sure that the JCT Constructing Excellence contract is the main contract between all of the parties to any construction contract. So it's more or less all on the same terms, which should make it easier to understand. However, that hasn't caught on. Whether it will in due course, I don't know. And everyone's sticking at the moment to the more traditional route of having individual contracts between parties to a construction contract, and all those contracts will slightly differ in their terms. So let's now have a look at design liabilities. SPC 2016, ICD 2016 with design, and MDW with design are not design and build contracts. They're only suitable where the contractor is to be responsible for a discrete element of the design. So in completing the design for the works, the contractor is required to take responsibility either for the contents of the employer's requirements or for verifying the accuracy of the design contained in the ERs. JCT SPC clause 2.13. That provision appears to have been intended to counter the possible implications of a case called the Cooperative Insurance Society against the wonderfully named Henry Boots Scotland Limited, excuse me, where it was held that a contractor required to complete design work was under a duty of care to examine an employer's pre-existing design and to satisfy himself that this was such that it would produce a completed design so that the building itself could be built. Under the JCT, however, under SPC 2016, DB 2016, and ICD 2016, the contractor is obliged to notify any inadequacies in the employer's requirements that they become aware of and seek reimbursement by way of a variation to the contract. Plus, it is incumbent on the contractor to ensure the employer's design complies with any statutory requirements, except in DB 2016, where the employer's requirements state that they are so compliant. Now, it's open to employers to delete and amend the provisions, and they often do. Employers will commonly seek a chain of amendments to the requirements and to the provisions to reverse this allocation of risk, namely to make the contractor responsible entirely for the design contained in the employer's requirements. Slightly unfair, but that's what the effect is of these amendments. The contractor is therefore required to undertake any design work to the standard expected of an appropriate professional consultant, such as an architect or consulting engineer, appointed directly by the employer and not undertaking any construction work. JCT SPC 2016 contractors design documents. These are defined in the contract as the drawings, details, and specifications of materials, and workmanship and other related documents prepared by or for the contractor in relation to the contractor's design portion. The contractor's design submission procedure is set out in Schedule 1, and this sets out a submission, approval, and communication system in relation to the contractor's design documents. This procedure and the employer's involvement in it does not affect the contractor's liability for design. So given that the contractor has got liabilities for design, he obviously needs to make sure that he has a professional indemnity policy that will protect him against any errors in the design of the project. And that at the moment is easier said than done. Standard form contracts, key provisions and mechanism. Matters of interpretation of contracts are a matter for the English courts to determine. At common law, a contract will generally be construed as a whole. So all of the conditions, etc., and attachments and everything else to a contract will be read together. The English court does not look at a contract, in a clause in a contract, for example, just in isolation. It will read the whole contract and then look at that particular clause, if that clause is in dispute, in the context of all of the contractual documents, including any attachments, schedules, etc., that are referred to in the main contract. Now, where there is ambiguity, so very often you will have two clauses in a contract which seem to contradict each other. The courts, through common law and case law, develop certain principles which they apply as an aid to interpretation. So there's a rule of construction that greater weight should be given to conditions that have been specifically drafted against those which are of a standard nature. So, if you have a standard form JCT contract, but it has been amended specifically by the parties, by amendment of a clause, the court will give greater weight to that, because quite clearly the parties intended something slightly different than the standard conditions contained in the JCT contract. Now, in some standard forms of contracts, such rules of construction are circumvented by express terms of the contract. Now, that doesn't mean to say that the court's jurisdiction is excluded entirely. It doesn't. No one can exclude the court's jurisdiction. But what it does mean is that, sorry, there's a pigeon on the roof, apologies. What it does mean is that you can make an attempt to say that, for example, everything in this contract is the entirety of the contract and nothing else should be referred to, etc. So the general rule is that if you've got handwritten amendments, these are often preferred over typewritten amendments, and these are both of those are certainly preferred over printed. Handwritten amendments have I suppose, a special place in English law's hearts, because quite clearly the parties, perhaps at the last minute, have made amendments to the contract which they intended to be binding upon both of them. Okay, but the hierarchy of documents, including common amendments to the standard form, you need to be careful of that. But I hope I've made the point clear that a standard form printed document without any amendments to it at all, well, the courts would certainly look at that. But if there are then typewritten amendments to it by way of an addendum or further schedule, and in particular if they've got handwritten amendments on it, these will be looked at far more carefully by the courts than just a standard printed form of contract. Now this, unfortunately though, and in no way am I being critical here of our fine construction industry. Please don't think I am, I'm not. But this does lead to problems. It leads to problems when amendments are made about there's errors and inadequacy in the contract bill and the supporting documents. There are often inconsistencies in and between the documents generally, and also in and between the documents relating to CPD. Because what the construction industry tends to do, and we come across this a lot, is that in their rush to, for example, secure a contract, the contractual documents are not generally, there are of course exceptions, generally looked at particularly closely. The industry tends to just, especially with JCT contracts, just say, oh, well, it's a JCT contract. We all know what it says and we'll make some amendments to it. Well, that's fine, but very often the amendments aren't made. If they are made, they are illegible. And this does, of course, lead to problems with regard to interpretation of the contract. So you might have two versions of a drawing revision and the wrong version gets signed. We've seen that a lot. Sometimes the drawings referred to in a contract as an attachment aren't attached. And nobody, 2-3 years later, can work out which was the correct document, correct drawing to attach. You might have a contract drawing list that does not correspond with the drawings that have been actually signed. Very often there is a failure to complete contractual documents. A number of times that we receive documents, and there is not one little bit of squiggle on it to indicate that any party signed it and agreed to be bound by its terms. There's often a failure as well to complete formalities, especially if a document's to be executed by deed. If you don't execute a document properly, then certainly you will be bound, and this is particularly common when a document's supposed to be executed by deed, to a 6-year time limit as opposed to a 12-year time limit. So we get these problems a lot because as a whole, the industry doesn't really concentrate on making sure that the contractual suite of documents is correctly signed, correctly executed, and actually, for want of a better word, ladies and gentlemen, makes sense. The Contracts Rights of Third Parties Act 1999, third parties may achieve entitlement to an enforceable benefit by either of two routes provided by Section 1.1 and Section 1.2 of the Contract Rights of Third Parties Act 1999. Where the contract expressly states they may enforce a term in a contract, they may do so in their own right. And where the terms of the contract purport to confer benefits on them, provided under Section 1.2, that it cannot be construed on a proper construction that the parties to the contract did not intend the term to be enforceable by others. Section 1.3 provides that third parties may be identified by name as a member of a class, so purchasers or subcontractors, or by description. They need not be in existence when the contract was entered into either. On the subject of acts that give third parties rights, remember there is also another act, the Third Party Rights Against Insurers Act, which came in 2013. And that's an interesting act because one of its clauses enables a shoemaker contractor is going to become insolvent. And it's become insolvent because it made an error during the construction project and was likely to be exposed to significant claims against it. And it decided, instead of doing that, just to go into liquidation. Now, if that company has gone into liquidation, but one of the things that it was being pursued for would be something that was capable of being insured, let's assume that the bus contractor did actually have insurance, then you may well be able, you can step into the shoes of the contractor and claim on the insurance policy. Now, it's not been used very often yet, but it is there. And I just thought I'd slip that in and mention that as we're talking about third party. How do parties enforce such a provision? Section 1.5 gives the qualifying third party the same remedies as he would have as if he were a party to the contract. So even though he's not a party and only gets benefits from the contract because he's a third party, he still gets the same rights as if he were a party to the contract. Now, you also need to make sure if you're going to have third-party rights that the third party knows about it, and so you need to give a proper notice. Third-party rights for purchasers and tenants under the JCT. These rights and limitations are set out under Schedule 5, paragraphs references there. They include rights granted by the contractor as being, for example, works to comply with the contract and be good practice. Excuse me. The contractor's liability, no right to take instructions, use of contractor's design documents. There are always provisions regarding professional indemnity insurance, assignment, giving of notices, and enforcement of rights. Under the JCT, these rights and limitations are as set out under Schedule 5, Part 2. Note the difference in this respect. No rights are granted by the employer acknowledgement where the funder exercises step-in rights. They include rights granted by the contractors being works to contract practice, the contractor's liability. No rights to take instructions unless he steps into the place of the employer. Step-in rights, the most significant difference here. Use of contractors' design documents, professional indemnity insurance assignment, giving of notices, and enforcement of rights. Collateral warranties. The employer may want the contractor to grant rights to purchasers, tenants, and to the funder, but by way of a collateral warranty. Clauses 7C and 7D. Similarly, they may want the same for beneficiaries to benefit from the rights granted by subcontractors under Clause 7E. The collateral warranty is no more than an obligation to enter into a separate agreement upon specified terms. This to date is the most common and tends to cause the majority of problems, because guess what? People don't enter into a separate agreement upon specified terms. And while it is triggered within the contract particulars, the procurement and delivery of such agreements can lead to difficult processes. The promise given by the contractor in the warranty is given as at practical completion, so the request can be made up to and following practical completion. Most in the industry will understand the difficulty in procurement if the contractor or any other party does not enter into the required warranty, then clearly no benefit can be enforced. Excuse me, it goes back to the point I made earlier about there is not enough attention paid by contractors and others at the time of the formation of the contract. There are a number of areas that I've already highlighted which cause difficulties: non-signature of documents, wrong documents being attached. But also when it comes to collateral warranties, great many people don't actually execute them. As I've said there, you don't enter into the required warranty, then clearly you can't, there's no benefit that can be enforced. So this whole contractual matrix at the start of the contractual process, or the contractual commitment process, really does need to be paid more attention to. And under most standard forms, there are no sanctions in the contract for failing to impose notice. So what's the solution? What are the common problems with warranties? Well, TPR versus collateral warranties. Enforcement. ease of obtaining, reduction of administration and habits, including step-in rights for the funder. I suppose my view is that I would rather have third-party rights than collateral warranties. However, there are some other solutions that you can look at, and these are available from the financial market. We're going to have a look at these now. Types of bond, what the surety market actually is. Should you be going to the surety market or to a bank? And is it conditional or on demand? Apologies again. Bit of a dry throat this morning, apologies. Right, so what are the types of bond? Well, there's a bid bond, guarantees performance at the tender stage. There's a performance bond, which guarantees performance during the construction and defects liability period. There's a retention bond provided in lieu of a retention. And there are other types of bonds. There's an RPA bond, but that tends to be used by food importers, and HMRC duty deferment bonds, and these tend to be used by importers and exporters of goods. There's an advanced payment bond. This is provided where goods are ordered, but payment is deferred until delivery to site. They were particularly called on in the recent COVID-19 pandemic, surprisingly enough. There's also a Highways Act bond, public works, section agreements guaranteeing roads, sewers, street lighting, etc., will be installed to adoption standards. There's also waste licenses and shipment of waste bonds. Again, these are very specific to the waste industry. And pension bonds for companies that TUPE staff who have a legacy public sector defined benefit pension. There is also the surety market. A number of insurers, HCC, Aviva, QBE, RSA, Zurich, Euler Hermes, Chubb, Liberty, AIG, and others, all will provide sureties. You should, if you're going to go down this route, you should make sure that your insurer that you're choosing has a minimum standard of A rating with standard and poor. Now, so I think we all probably know there are a number of issues with the insurance market at the moment. We are in a hard market, the first since 2002. The 2002 market was caused primarily because of 9/11, which was a huge hit on the insurance market. There was also floods in Europe as well, the worst for some considerable time, and that caused a glitch in the insurance market and meant that temporarily, and I'm only talking a period of a year to 18 months, insurance rates went up. However, since then, a series of events have taken place, which has meant that the insurance market is becoming increasingly risk averse. And that will also include the provision of sureties because of four main reasons. In 2018, Lloyd's did a review of the syndicates that operate under its umbrella and found that they were writing business at an economically unsound level. So that if there was to be a major catastrophe, they wouldn't have enough fund reserves to pay the claims, which means that they'd have to go to Lloyd's to pay out of central funds, and Lloyd's don't want that to happen. So they told their syndicates that they either started to write business at a commercially profitable rate, or don't write it at all. And guess what? A number didn't write it at all. And just like everything else, if you've got fewer people providing a service, they can charge more for it. So they did. They also contracted the cover they were going to give, and the same would apply to any sureties. They made the terms and conditions, as I said, much, much harder and covering less. In addition to that, there was then a premium rise on top of the one caused by the lack of syndicates. This was due to a small incident with an aircraft called the 737 MAX, which, as you know, doesn't work, and Boeing claimed on its various insurances, and it had a great deal of them. And in addition to that, there was Grenfell. I cannot overstate how much Grenfell and the likely outcome has had an impact on the professional indemnity market. It has made rates go through the roof, and the same also applies to sureties. You're very unlikely to get any form of surety now if you have anything to do with combustible materials or cladding. It's just not going to happen at the moment. So whilst the surety market, for various reasons that I'll come on to, is still probably a preferred one to go to, its cost has gone up, the coverage offered has gone down, and they are much harder to get. There is a much higher level of due diligence. Of course, banks will provide them. HSBC, Lloyds, Barclays, all the big banks do provide sureties. However, please, ladies and gentlemen, one thing you mustn't do is go offshore. The chances of me successfully recovering monies due from an insurer based in Russia are frankly nil. The chances of me recovering from, say, lead Indian insurer, yeah, bit better, but the Indian legal system takes years and years and years. So please don't go offshore, with the possible exception of America. If you do take an insurer who's providing you with a surety and is based overseas, the chances of me successfully being able to enforce that are slim. Yes, it will be considerably cheaper, but it won't really provide you with any additional benefit. The market share at the moment, insurers about 30%, banks 65%, and yes, unfortunately, there are still people going offshore, which accounts for about 5% of the market. Surety or a bank? Well, banks typically require 100% collateral through cash coverage or a charge to support the bond. Sureties, however, start point is zero collateral, and sureties will accept the insolvency risk. In addition, banks, as is in common with just about everything else the bank do, will want monies lent, return, etc. on demand. There is no notice period or anything like that. It will be on demand. And sureties, with a few exceptions for certain types of bond, will always recommend conditional bond wordings. Quite sensible, that. So that, yes, they'll pay conditional upon, etc. So remember that. The sureties market is probably still better, but as I've said earlier, I'm giving you the warning now that it will be harder to get, there'll be less coverage, and the costs will have increased. Some banks have also retreated from sureties, but they still dominate the market, in particular Ireland. But sureties often have stronger credit ratings, and their market share is steadily increasing in the UK. I think that's probably stopped now since I did these slides. I suspect that it's probably now decreasing again. In the US, sureties have a 90% market share. So they are by far the preferred option when it comes to it. As said, I'm just repeating again, I do think those who do take out sureties, they do need to read them again now, because the wording, etc., will have changed. And there will probably be something in there that specifically excludes anything to do with cladding, anything to do with combustible materials, etc. Should you have a conditional or on demand? Well, conditional contract guarantee bonds are triggered by breach of contract, and they include insolvency as well. On-demand bank guarantees, remember this, do not follow the contract. And they can be triggered on the beneficiary's request. For performance bonds, you should always avoid performance bonds. The Association of British Insurers are against them, and the Office of the Deputy Prime Minister has also said on numerous occasions that performance bonds are not the best. ABI model bond forms are equitable for all parties, and amendments can be negotiated. Bond information requirements, and this is more or less the same for sureties as well. They will want, and this is a non-exhaustive list. There will be much more being asked for at the moment, I suspect. But the minimum that you'll be asked to provide is general company information form, bond application form, a bank information form, a bank facility letter, bond wording, budget and forecast accounts, including cash flow forecast, current order book and what's in your pipeline, audited reports and accounts, management accounts and supporting balance sheets, land and development schedules. All of this will be required as a minimum in order to obtain bonds and sureties. And I suspect that list has been considerably added to, especially by the surety market, given that the insurance market itself is going through a time of crisis. So conclusion, I hope that's been useful. My main points really would be: one, make sure at the contract formation time, please, that you get your contract into good order. If you have made amendments to the contracts, and these often happen, and there's nothing wrong with that at all, make sure they are clear, legible, and signed by both parties. Make sure the attachments to the contract are the correct attachments. Make sure that any collateral warranties are duly executed. So make sure the contract suite is correctly formed, that contracts have been signed, anything to be executed under a deed has been executed under a deed. Think about getting bonds and sureties. If you do all of that and you do get problems, it will make any solicitor's life a lot easier if he has a suite of documents which are properly executed, clearly legible and understandable. It will save an awful lot of money if both parties have agreed one set of documents and there's no argument that they did. So that's really all I have to say, and I will now pass you back to the very lovely Miss Julie Campbell.
Thank you, Mr. Sharp. Okay, thank you for that. Questions, if anyone has any questions, please put them in the Q&A or the chat box now. Although it appears you have explained everything so beautifully that everyone understands everything now about project security. I know we're with you again tomorrow, aren't we? We're on the construction roundup. That's tomorrow evening at 6 p.m, where John will be joined by Mohammed Hack and indeed Richard Silver to discuss hot topics currently in the construction marketplace. So please feel free to email us on seminars@silverllp.com if you would like a place. We do have a question. Someone's asking, why are performance bonds not preferred these days, John?
Because, well, given the situation that we've just had in terms of pandemic, etc., As you can imagine, performance bonds were, if you had them, you were lucky, I suspect. You may have got some, but performance bonds are generally not preferred. There's too much, I think, general uncertainty, and performance bonds are always open to interpretation a bit too much. I'm not saying it's not so, there's no particular legal reason why you shouldn't have a performance bond. It's perfectly fine. But they're just defining the term performance, unless it is very clearly set out, and does tend to cause interpretation difficulties. One person's idea of performance under a bond it always causes problems. So whilst I'm not saying you should have them, by all means do, there are some warnings attached to them. Actually, when I did the slides, there was actually a very good note on the Deputy Prime Minister's office about performance bonds. It's worth a read. It's simply a mark of caution. I'm not saying don't do them. I'm not going to be any particular legal reason why you can't do them. Just say, just be wary of them and understand what you're entering into. And in particular, make sure that if it does say performance, that what type of performance, and it should be very clearly defined.
Right, okay, noted. So you're not saying no, you're just saying take care, please.
I'm saying take care, have a read round the subject. As I said, that I found was very useful. The Association of British Insurers as well, I've also got a useful note on them. Just be careful, that's all.
Okay. Right, that appears to conclude today's seminar. So we'll say thank you very much, John, as always, for your time. Thank you everyone for attending. Hope you have a great day. And if anyone does want a place to log in for tomorrow's seminar, as I say, please let me know, seminars@silverllp.com. And if there's anything you'd like to ask John but didn't want to ask in an open forum, it's Jon Sharp, that's Jon Sharp @silverllp.com. And we look forward to seeing you all again soon. Thank you, John.
Thank you, Julie. Thank you, everyone. Good evening. Good afternoon.